Hi, very good morning. It's a Supreme Court judgment on income tax. K. Krishnamurthy versus Deputy Commissioner of Income Tax. This issue relates to penalty under Section 271 AAA, Triple A. Simple facts are that search and seizure operation was carried out at appellant's premises. As a consequence, appellant disclosed an income of approximately 2.27 crores. Then notice was issued calling for return of income for the assessment year 2011-12. Assessment year is very important. Appellant returned a total income of rupees 4.77 crores. At the time of search and seizure, he offered 2.27 crores. Then at the time of assessment, assessee total income offered was 4.77 crores. So additionally another 2 crores he offered as his income. Assessment order was passed. Then penalty proceedings were invoked under section 271 AAA. Two separate orders were passed on the same day, one for assessment year 2010-11 and another order for assessment year 2011-12. So against both the orders levying penalty, appellant preferred appeal before the Commissioner of Income Tax. Appeals. Appeal relating to assessment year 2010-11 was allowed. Reason was they said it is not the specified previous year. Let us not worry about that way. That is allowed. The appeal relating to assessment year 2011-12 was dismissed by the CIT appeal. For the reason you did not comply with section 271 AAA2. That is the reason the CIT appeal said and dismissed. Then this appeal was carried to the tribunal. Tribunal also dismissed. High Court also dismissed this appeal. Then an appeal was filed before the Supreme Court. Supreme Court, on going through section 271 AAA1, Supreme Court held the imposition of penalty under that section is not mandatory. This is very, very important. Penalty under section 271 AAA1 is not mandatory. It may be levied if there is undisclosed income in the specified previous year. Supreme Court said that the discretionary power of the assessing officer is not unfettered, unbridled, or uncanalized. Discretion means it must be a sound discretion guided by law. It must be governed by rule and not by humor. It must not be arbitrary, vague and fanciful. Then Supreme Court looked into 277 AAA2. AAA2 specifies 3 conditions. If these 3 conditions are fulfilled, then penalty under section 277 AAA1 will not get attracted. The 3 conditions are: 1. In a statement given under section 132(4) within bracket 4, in the course of such, assessee admits the undisclosed income and specifies the manner in which such income has been derived. That is the first condition. He specifies the manner of the undisclosed income, how that income was derived. Then 2, he substantiates the manner in which such income was derived. So first class, he specifies the manner. Second condition, he substantiates the manner. And third condition is he pays the tax and interest on the undisclosed income. If these 3 conditions are satisfied, then penalty under section 277 AAA1 is not applicable. Supreme Court says even if the tax and interest are paid with delay, in the absence of specified period of compliance, penalty under section 277 AAA1 is normally not leviable. Normally, the Supreme Court is not saying it is not leviable in all circumstances. I don't know why the Supreme Court used the word normally. And Supreme Court did not explain, or it is silent. What are the normal circumstances and what are the abnormal circumstances? Now there is scope for interpretation again by the assessing officers. No, no, this is not a normal circumstances, so hence I am levying this penalty, they will say. So I don't know whether this word normally used by Supreme Court is intentional or unintentional. That is what I want to say. Supreme Court says, even if tax and interest are paid with delay, in the absence of a specified period of compliance, penalty under section 277 AAA 1 is normally not leviable. That is what Supreme Court says. Supreme Court then considered the expression undisclosed income that comes under the explanation clause of section 277. Supreme Court says section 277 AAA is a penalty provision and hence it should be strictly construed. The fact that the assessee surrendered some undisclosed income during the search, or that the surrender is emerging out of statements recorded during the search, is not sufficient to fasten the levy of penalty. That alone is not sufficient. The onus is on the AO, assessing officer, to satisfy the condition precedent stipulated in the explanation before fastening the levy of penalty. It is obligatory on the part of the AO to demonstrate and prove that undisclosed income of the specified previous year was found during the search or as a result of search. Again, I am not able to understand. If something is found, suppose a thief is caught, he voluntarily discloses these are the things which I have stolen. Then what else needs to be proved by the assessing officer? Supreme Court says, I can understand 277 AAA 2. Suppose if he pays penalty and interest immediately, then section 277 AAA 1 is not attracted, I can understand. But Supreme Court here says, the onus is on the AO to satisfy the condition precedent stipulated in the explanation before fastening the levy of penalty. It is obligatory on the part of the AO to demonstrate and prove that undisclosed income of the specified previous year was found during the search or as a result of search. So, with reference to the case on the specified previous year, the facts of this present case disclose that the search was conducted on 25/11/2010. Dates are very important, only 2 dates. So, search was conducted on 25/11/2010. The year for filing the returns ended prior to the date of search, that is on 31/7/2010. Consequently, in the case, the specified previous year will be only AY 2011-12 and not AY 2010-11 by applying the explanation given under that section. Supreme Court, while considering the assessment year 2011-12, divided the total income offered by the assessee into 2 parts. One is the income which was disclosed by the assessee during the search, on which he has paid the tax and also the interest. The other is which was disclosed during the assessment proceedings. Supreme Court held that the condition prescribed under section 271 AAA 2 was complied with by the assessee on the portion of the undisclosed income found during search, and hence no penalty under section 271 AA1 is leviable. Because already he has accepted that, he offered that income of approximately 2 crores, and then he has paid the tax and interest thereon. But as far as the income disclosed during assessment, this was not disclosed during search. So the argument that the transaction was not found during the search at the appellant's premises, but due to search at some other place, was not accepted by the Supreme Court. Supreme Court said this was collected as a result of or in continuation of that search only. Supreme Court was of the view that the causation for collection of the details was the search at the appellant's premises. Then it cannot be said that the documents were not found in the course of search. Because even if I collect it later on from somebody else's premises, or from I collect some information from somebody else, then also it is only a continuation of that search. It is not a separate act. That is what it says. The cause is the search at your place. And these are all the side effects which are coming. Supreme Court explains this. The term found in the course of search is of wide amplitude. It does not mean documents found at the assessee's premises alone during the search. At times, search of assessee leads to search of another individual and or further investigation or interrogation of third parties. All these steps, recoveries would fall under the expression found in the course of search. That is why Supreme Court said, as far as the second portion, whatever income you have disclosed, because of the documents collected from another third party, this was not offered at the time of search and no tax and interest was paid. Hence, 271 AAA penalty can be levied on that portion of the income. This is what Supreme Court said. Supreme Court confirmed the penalty on the part of the amount that was offered during assessment and deleted the penalty on the amount disclosed at the time of search on which tax and interest was paid. That is the final conclusion. Thank you very much. Have a great day.